Good morning, Council. Today's date is October 4th, 2022, and we are going to hear two arguments by video conference, yours being the first, State of Ohio versus Jonathan Geib. Its case number is 21CA0019M, 21CA0020M, and 21CA0021M. As you can see, the panel is Judge Hensel, Judge Sutton, and I'll be presiding and keeping track of time. So Attorney Hall, before you start, if you'd let me know how much time you want to reserve. You can reserve up to 5 minutes for rebuttal.
Thank
and
you.
That way I'll let you know as you get close.
Your Honor, my argument, I'll use 10 minutes, and then I'll like to reserve 5 minutes if needed for any rebuttal. Thank you.
All right, and then Attorney Lanier, of course, you'll have 15 minutes for your argument. We don't use the names of children or victims in the arguments. Please refer to them some other way. I can assure you, Judge Hensel, Judge Sutton, and I have read the briefs, and so we are prepared to hear the arguments.
Thank
Attorney
you.
Hall?
Thank you, Your Honors. Good morning, Your Honors. Good morning, Mr. Lanier. Attorney Eric Hall on behalf of the appellant, Jonathan Geib. Mr. Geib was charged with, in 3 different cases with 5 counts. He was charged with 2 counts of criminal mischief, 1 count of disorderly conduct, 1 count of sexual imposition, 1 count of assault. The case proceeded, and all these charges were regarding his girlfriend, Your Honors. Case proceeded to trial. It was a jury trial. The jury came back with a verdict of guilty on assault, guilty on 1 count of criminal mischief, guilty on a count of disorderly conduct. Mr. Geib was found not guilty of the additional charge of criminal mischief and also of the charge of sexual imposition. 2 assignments of error, Your Honors. The first assignment of error is that the trial court erred and abused its discretion when it would not grant a continuance or allow newly appointed counsel to withdraw. Attorney Wesley Johnston was appointed 1 week before the trial in this case when the appellant's retained counsel had withdrawn from representation. Motions were filed in this case asking for a continuance. Those were denied. At the day of the trial, Attorney Johnson asked the court for a continuance, indicating that he needed more time to prepare, that he didn't have adequate time to prepare, and also that if he would not give him more time to prepare the court, then he would ask the court to allow him to withdraw. That way, appellant could retain counsel, which there was some discussion about appellant wanting to possibly retain counsel in this matter. Both of those requests were denied by the court. Then Attorney Johnson requested before the start of the trial 5 minutes to speak with his client, appellant Mr. Geib, which the trial court denied that, which that alone, it was an extraordinary constraint, not allowing newly appointed counsel 5 minutes to speak with his client before the start of a trial. A very serious case involving 5 different charges, 3 cases would, if the appellant would have been found guilty on all these charges, he could have spent a significant amount of time beyond what he did serve, which I believe was 105 days in jail. He could have spent well over a year in jail on these charges. The 5-minute request was certainly reasonable. Also, the request for a continuance, appointed counsel at 1 week. He didn't have an opportunity to interview any witnesses, to prepare a trial strategy, subpoena witnesses, and also the possibility of him working out maybe some type of a plea agreement on this case after having time to sit down and go through potential witnesses and evidence with Mr. Geib, and then having maybe a better assessment of the case in order to properly counsel Mr. Geib on the chances of going to trial, what the possible outcomes would be, what the possible chances would be, and then also the possible plea offers out there. 1 week is not a lot of time for an attorney, and it wasn't enough time for Mr. Johnson. He indicated that on the record too, Your Honors. I think the trial court's decision in not granting these requests was unreasonable, was arbitrary, and certainly I think was an abuse of discretion. It would not have prejudiced the state in any way to allow.
Attorney Hall, was any of this discussed with Attorney Johnson before he accepted the appointment 1 week before trial? I mean, I'm assuming he knew the trial date was imminent when he took the appointment.
Oh, Your Honor, I am sure, on the record, I'm sure that Mr. Johnson was apprised that when he was appointed on the case, that trial was going to be 1 week from his appointment. I'm certain of that. But I think that the motions filed, that Attorney Johnson probably thought that the court would have given him a continuance based upon the short amount of time that he had to prepare. Those motions were denied. I think Attorney Johnson probably felt an obligation, which I indicate that in my brief, that, the alternative in this case, if Attorney Johnson would not represent the appellant, Mr. Geib, then Mr. Geib would be required to go forward on his own, which was certainly untenable. Okay, Mr. Geib would not have been able to properly represent himself. He's not an attorney. He's not legally trained, and he would not have been able to do that, certainly. So I believe Mr. Johnson felt an obligation, and even under these extreme constraints, not to have Mr. Geib go forward unrepresented, Your Honor.
The timing on that motion?
I believe these motions were filed probably within a few days. I'm sorry, I don't have this in front of me, Your Honor, but I can imagine Mr. Johnson, being a diligent attorney that I know him to be, would have filed motions probably quickly to try to continue the case. And then
Okay.
Of course, those motions were denied, and he renewed those motions orally at the time of trial.
Thank you, Attorney Hall.
Thank you. The second assignment of error is that Mr. Geib, just based upon Attorney Johnson's representation to the court because of the time constraints, Mr. Johnson on the record indicated that he would not be able to properly and adequately represent Mr. Geib in this trial. Now, I know the argument's going to be from the state that while the trial, Mr. Geib was found not guilty of probably the most serious charge, which was the sexual imposition charge. He was found not guilty on the one count of disorderly conduct. One count of criminal mischiefs. So the argument would be that Attorney Johnson was able or prepared enough or adequately represented Mr. Geib enough to get a not guilty verdict on those two charges. But had he had more time, as I said before, he could have interviewed witnesses, subpoenaed witnesses if necessary, and developed a trial strategy with Mr. Geib, which during the kind of time constraints he just wasn't able to do. So Mr. Johnson did something that I would have to commend him for. He told the court that he would basically be ineffective if forced to go to trial on this. And so that's why I've included that as an assignment of error in this case, that the time constraints, it's not any basically reflecting on Attorney Johnson's ability, but just the time constraints alone for any attorney to go to trial in that short period of time, that those constraints would cause them to be ineffective in some way or manner, and in some instance, Your Honor. Thank you.
Well, do you have specifics for me as to ineffectiveness?
Well, just the fact that there are things that ordinarily an attorney would have done. He would have decided if there was any possibility of any witnesses out there that could have been other than Mr. Geib and of course the alleged victim in this case, which was his girlfriend. Also maybe developing some kind of strategy with Mr. Geib. Mr. Geib had gone through, my understanding, several attorneys. Okay, the last attorney that withdrew before trial, I don't believe was the first attorney that he had. I think he had other attorneys. So apparently there was some lack of a attorney-client relationship, or the attorney-client relationship broke down with those attorneys at some point or other that they withdrew. Attorney Johnson needed some time to develop that attorney-client relationship to try to help Mr. Geib. He wasn't able to do that with those time constraints, Your Honor.
And Attorney Hall, is that going to be supported by the record? In other words, did counsel indicate that he didn't have time to subpoena the necessary witnesses and some of the other things that you have indicated? Are we going to find that in the record?
Your Honor, I'm sorry, I apologize. I don't think it's in the record itself. I think he was just asking for more time, but I guess it would be a reasonable inference that more time would include those things for any attorney, to do a proper investigation of the charges before trial, to see if there's any witnesses and can you interview those witnesses, and some other things, maybe to do a background check of the alleged victim and see if there's anything that could be used as far as impeachment purposes. Those are all the things that any attorney would do on a criminal case. And I think what Mr. Johnson was indicating, that he didn't have enough time to prepare the case, and I would infer that those were the things that he would have done and didn't have enough time to do. Your Honor, thank you.
All right, thank you, Attorney Hall. Let me check with Judge Sutton and Judge Hensel. Either of you have any questions for Attorney Hall before we hear from Attorney Lanier? All right. Thank you, Attorney Hall. Am I pronouncing your name correctly? Is it Lanier or Lanier?
I don't know if that was helpful or not.
No, I did. You were on mute when you said it.
Oh, okay, sorry, Lanier.
Lanier. Okay, that's what I thought. All right. You will have 15 minutes and you may proceed. Thank you, Attorney Lanier.
Thank you, Your Honors. May it please the court, Mr. Hall. I'll respond kind of in order. The two issues that were filed by Mr. Geib in this case. I want to first point out the initial number of cases and charges described by Mr. Hall was off a little bit. It was 4 different case numbers at the municipal court level, and there were 6 charges. And Mr. Hall was correct. He was found guilty of 3 of the charges, but he was found not guilty of 3 charges, which included 1 criminal mischief count, 1 count of assault, and the sexual imposition. So there was actually 2 assault charges in this case. 1 he was found guilty, 1 he was found not guilty. Looking at the suggestion that the trial court abused its discretion in not granting the continuance, I looked to the specifics of the continuances in the day before and the day of the jury trial, beginning with Mr. Johnston, who ended up being the trial attorney in the case, attorney number 3. He did file a written motion to continue the jury trial the day before. In it, he explains that the defendant wants to track down, introduce police reports and materials for cross-examination of one of the potential state's witnesses, the mother of Mr. Geib's child. He renews that orally the next day at the start of the jury selection. Again, his first basis is wants to introduce evidence, civil matters regarding one of the witnesses. He refers to it as being his baby's mom. A little bit later in the transcript, we disclose her identity. Now, I indicated in response to that, I didn't get a chance to respond in writing to the motion to continue the day before. It got ruled on before I had a chance to do that. But orally, the next morning at the start of the jury selection, I indicated that this witness, the mother of his child, was not a witness in the case in chief, but was just potentially a rebuttal witness. As it turned out, that witness did not testify. Mr. Geib was in no way prejudiced by not having any reports and or civil filings that he could use to cross-examine her, because she never testified. I didn't call her, the defense didn't, or the defense didn't call her, so she didn't testify. Separate from that, she was on a witness list that was submitted much earlier to the defense. That was filed in compliance with the court's rule. I believe it's was filed about a week before. So that name was familiar to the defense. Obviously, if he had pending civil litigation, he knew a little bit about her. The second basis in his written motion was that the defendant requested he withdraw his counsel. The judge of the trial court looked at that motion, immediately issued a ruling denying that. At the same time, attorney number 4 filed a motion to continue and a limited notice of appearance, which suggested attorney number 4 would only take the case if it was continued. The judge also issued a written decision the day before the jury trial that indicated we're not going to continue the case, so your limited notice of appearance, we're not going to consider it. You're not attorney of record. Again, we skip back to the next morning. The second basis that Mr. Johnson puts on the record is that he wants, or that the defendant has retained attorney number 4, and attorney number 4, needs time to review this and get prepared for trial. Orally, then we went through that, and the judge said, well, when I say the judge, it's difficult because the judge that ruled on the motions the day before was not the judge that heard the jury trial the next day. elected Judge Warner ruled on these the day before, but it was an acting judge who heard the jury selection the next day and then the trial the following day. But he reviewed that entry and indicated that no, in fact, attorney number 4, their limited notice of appearance had been denied. So attorney number 4 is not the attorney of record, and they're not here to represent him. So that was the basis for denying that. Judge Teodosio, to answer your question earlier to defense, was there any suggestion by Attorney Johnston that subpoenas needed to be issued in the record? Early on in the transcript, I would call that maybe part 3 of his motion to continue on page 10. And this is orally done by Mr. Johnston, pages 8, 9, and 10. But on page 10, he does indicate that subpoenas need to be issued. To me, I interpret that as subpoenas need to be issued going back to his first basis, which is to gather some information to cross-examine the witness who ended up not testifying. But the court did respond to that and said, well, we're just doing jury selection today. We have the clerk of courts, the bailiffs are here. If you need to get some subpoenas out for the start of the trial tomorrow, we can get that done. We're not going to continue the case, but we can get that done. So, the standard is, was this an abuse of discretion? And I outlined in my brief that it really wasn't. This case for a misdemeanor was rather old. We were 10 months from the offense dates and 8 months from when the case had been filed. The state had prepared, had witnesses lined up. The trial court had prepared. Because of the number of witnesses and the fact of the number of charges, we had set 2 days aside to get this done. We were going to do the jury selection the day before. Typically, we do a 1-day jury trial, but we were going to do the jury selection the day before, do the jury trial the next day. So the court was prepared. I was prepared. I had a rather exhaustive witness list. Many of those people were under subpoena and were there that morning to try the case. Some of the other things this court should look at was in the request for continuance was a specific time amount requested. That was not. Another thing to look at, did the defense or defendant contribute at all to this needing of a continuance here the day of the trial? I argue that he did in fact contribute. We had worked this case out once before in early January. The parties had come to a resolution via pretrial. We put it in writing. The court, in attempting to do the change of plea, which would have been on the date of the first jury trial, the defendant reneged on that agreement, stated his relationship with the attorney had broken down. They let attorney number 1 withdraw at that time. The judge put out an entry that said, we're going to set this at least 30 days out. And 2 times in that entry said, because of the nature of the case, the age of the case, it's got to be tried. We're not going to continue it. And then a second time says, Mr. Geib, let new attorney know the date because we're not going to continue it. It's going to go forward. This case is old. We're going to go forward on this date. So then attorney number 2, Mr. Cafferkey, is on the case for, I think, about 12 days. He gets off the case. Then attorney number 3, which is Mr. Johnson, gets appointed somewhere in the 7 to 10 days before the trial. He happened to be in the court. He does criminal defense work. I personally checked with him and said, I think they may want to appoint somebody on this case. Are you available on these 2 days for the jury selection and the jury trial? He indicated to me, that he was able to take the case and could do that. And then attorney number 4 files that limited notice of appearance the day before the trial. I would argue that the defendant contributed to the needing of, if in fact he really needed a continuance, the day before and the day of the trial. I think when you look at all of those facts, I would urge you to find that it was not an abuse of discretion by the trial court in writing the day before to deny the 2 continuances, or the day of to deny his oral request for a continuance. With regard to ineffective assistance, I've kind of went through Mr. Geib's brief, And there's really not any specificity for declaring Mr. Johnson ineffective. It's just kind of a general, had he had more time, he would have been more effective type argument. And courts have looked at that vague request or vague suggestion as insufficient to show that counsel was ineffective. It's presumed that a licensed attorney in Ohio is effective at the trial. I cited Cleveland versus Graham in the 8th District, 2014 Ohio 3413, because it specifically says vague allegations of being unprepared are insufficient to show that a defendant was prejudiced and that the outcome of the trial would have been different had counsel been prepared. So with that strong presumption, and again, the brief doesn't specifically point out any specific ways in which Mr. Johnson was ineffective or anything he did that would have risen to a level of ineffectiveness. I would ask you also to deny that, that issue. And I think it is important to point out that there was 6 charges. After a trial, the jury did return not guilty on 3 of the 6 charges. But to suggest, more time or more effective would have been not guilty on all 6, there's no basis to suggest that. Thank you.
Thank you, Attorney Lanier. Judge Hensel, Judge Sutton, any questions? All right, thank you, sir.
Thank you.
Attorney Hall, you have 5 minutes for your rebuttal.
Thank you, Your Honors. Just briefly, I'd like to take up the second assignment of error first. Mr. Lanier indicated that, the cases involving vague allegations of ineffective assistance to counsel, the court has not found that those matters and the counsel was ineffective in those cases. But those vague allegations would be coming directly from the appellant or counsel looking at, for omissions or counsel's performance fell below standard. In this case, the allegations, it wasn't an allegation. Attorney Johnson was declaring himself to the court that he would be ineffective just because of the time constraints, because of the things that he felt that he wouldn't be able to do. So this wasn't really vague allegations coming from an appellant who was convicted and unhappy with the conviction. This was coming before the trial even started, that Mr. Johnson indicated to the court, hey, if I go forward, I'm not going to be able to properly represent and adequately represent this defendant. So that's a little bit different than these cases. It's coming directly from the attorney, even before the trial started. Usually most cases of somebody, it's all hindsight, and other attorneys looking at and say, well, Attorney Smith should have objected at this point or didn't do this. This is a case where from the get-go, the beginning of the case, Attorney Johnson, the counsel record says, look, I'm not going to be able to do this properly, and I'm going to be due to the time constraints. So I'd ask the court to take that into consideration. As far as the first assignment of error, the continuance, certainly the motions filed by Attorney Johnson indicate that the wheels were in motion, okay? he wanted to subpoena a witness that was a rebuttal witness that never testified and that he never called. But also he indicated that, the court indicated that he could have one day to send out subpoenas for anybody else that he might think would be a witness that he wants to be. That's simply not enough time. To get subpoenas out and the hope that the person you're trying to subpoena is actually going to be there and that they can get service on them, or to have time to, to consider who are we subpoenaing and what are they going to say. And obviously one of the things you don't want to do as an attorney, you don't want to subpoena somebody to court and put them on a witness stand if you don't know what they're going to say, if you don't know the answers to any of the questions that you're going to ask. That would be, that's very risky in a trial. So certainly to subpoena any witnesses, Attorney Johnson would have needed more time to do that, and also to consider whether the witnesses would be ones that he would actually call to testify. So again, I believe the trial court abuses discretion. Attorney Johnson wasn't asking for a lot other than just the continuance. They could have given him a week continuance, would have been enough time. And certainly the asking 5 minutes to speak with Mr. Geib, that was an extraordinary constraint. Even denying all the motions, okay, motion for continuance, motion to withdrawal denied, but to deny his counsel 5 minutes to speak with him before the start of a trial, that was extraordinary, Your Honor. And I would ask the court to also look at that, because that shows kind of a pattern of the court's position in this case, okay, regarding this defendant, okay? And I think it was an abuse of discretion. Thank
By the
you.
way, were all offers off the table on the day of trial, or was that still an option for the defendant? In other words, when you talk about that 5 minutes to discuss, was that one of the things that they needed to discuss, plea offer, or were all offers off the table?
I think you could always, at any point, you could always discuss a plea, whether the plea would be available, whether it was on the table still, or whether it had been withdrawn and could be put back on the table, or a different deal could have been made. That's always an option. And
Well, sometimes, the day of trial, prosecutors say, we're not offering anything at this point.
or the judge. Sometimes the judge will say, you have a plea deadline, either accept the plea or you go to trial on the
Sure.
indictment, or you plead to the indictment. That's it. Sure,
Sure.
absolutely. Yeah.
Was that the case here is my question.
I don't know, Your Honor. I know that he had reneged on a deal with other counsel. There was a breakdown in the attorney-client relationship. And my understanding, that deal, he reneged on that deal, and I don't think that that deal was offered again. Well, it may have been offered to Attorney Johnson, but as far as the record is concerned, I'm not aware of it.
All right. Thank you for that answer. Judge Sutton, Judge Hensel, anything for Attorney Hall before we wrap it up? No? You've got 24 seconds, so if there's anything else you want to say.
It's okay. I'm finished, Your Honor. Thank you very much, though. Thank you.
All right. Well, we want to thank you both for appearing here by Zoom today. We're going to take the matter under advisement. We'll issue a decision in due course here, and the clerk of courts will mail each of you a copy on the day the decision is released. You can also keep an eye out at the Supreme Court of Ohio's website where our decisions are posted. On behalf of Judge Hensel and Judge Sutton, we thank you for appearing here today by videotape.
Well,
Enjoy your
thank
day,
you, Your Honor.
gentlemen.
Thank you.